Well, thank you very much indeed. And I'd actually like to thank on your behalf, perhaps, ladies and gentlemen, Sir Omar and Thomas Paquette, who has also played a key role in organising this conference, in actually bringing us all together today to discuss what, as has been mentioned, is a crucial issue within international discourse, the road to international justice. Now, of course, at the centre of this discourse is the International Criminal Court itself, and specifically, as mentioned in our programme, the future of the ICC. It's always, I think, important at any conference like this, within any debate, to establish some common ground, or at least actually try to. The ICC is very controversial. There's no doubt about that. But I think there's one thing I'm positive that we can all agree upon, which is that the punishment of crime is one of the most noble aims of political community, regardless of whether that crime is at a local or national level, or whether that crime is at an international level. And the ICC has been tasked by those who signed the 1998 Rome Statute, the Rome Treaty, with investigating and prosecuting the most serious of crimes: genocide, crimes against humanity, and war crimes. And let us also be clear, there is no doubt that many people welcomed the establishment of the International Criminal Court, and that many of them were from the emergent and developing world. And in fact, I think the largest single block is actually from Africa itself. And there are many people, I think, and many Western governments who actually believe, or at least say they believe, that the ICC has so far succeeded, that it has established a viable institution, it has actually engaged in investigations and has actually prosecuted, and is in the process of actually prosecuting those who it believes have actually committed those very serious crimes. There are, of course, also, as has become apparent in the last 6 to 8 years, a number of questions about the ICC, questions increasingly asked, actually, within both the emergent and developing world, as well as by major powers such as the United States, Russia, China, and India. And it falls to me, perhaps initially, to just run through a few of these questions. The first question, of course, would seek to establish the legitimacy of the ICC, the International Criminal Court. From where does it actually derive its mandate? Is it by acclamation, or is it self-assumed? Is it truly a world court with universal jurisdiction in the same way as perhaps the International Court of Justice can be seen, or is it an international court, as it were, with a small I? And some would say perhaps even a European court for Africa. It has been pointed out, for example, that ICC member states only represent just over 1/4 of the world's population. A follow-on question, of course, is exactly how independent is the ICC? The Rome Statute, which established the ICC, gives the United Nations Security Council special prosecutorial rights of referral and deferral. And there are those amongst us who actually point out that 3 of the 5 members of the permanent members of the UN Security Council are themselves not members of the ICC. So they are in a position to actually refer and defer cases pertaining to the ICC without actually being a member of that court itself. Similarly, how does the ICC's funding base influence its direction? Does the fact that most of the court's funding comes from the European Union in any way influence its position? There are also questions, of course, as to how the ICC has come to select the cases it has chosen to investigate and upon which it has chosen to take action. The ICC, of course, invites submissions regarding cases or possible crimes and has received more than 8,000 such submissions. So far, as has been pointed out very clearly in the New Africa magazine and in a range of other fora, every single one of those people that the ICC has chosen to indict have been African, and perhaps understandably, Africans feel that they are under an unduly focused spotlight. It is not just Africans, of course, who have pointed out that at face value, the ICC would appear to believe that North Africans and Europeans are incapable of committing war crimes or crimes against humanity. There are also some who allege that the ICC's selectivity with regard to those alleged crimes that it has chosen to pursue has in effect afforded de facto immunity and accorded impunity to several serial abusers of human rights who happen to be friends of the European Union or the United States. And there are, of course, also questions as to whether the ICC so far has ducked the more difficult issues. Its first prosecution, that of Thomas Lubanga from the Democratic Republic of Congo, which has lasted several years and has only just reached a verdict stage, was of a Congolese politician accused of using child soldiers within a country self-evidently torn apart by crimes which at face value present themselves as war crimes, crimes against humanity, and even genocide. The court has also faced a number of basic questions with regard to its administration and procedures. The court has cost almost €1 billion so far and has only just completed, as mentioned, its first case. Guarantees of swift justice would also appear to have actually fallen by the wayside. And Thomas Lubanga has been in ICC custody since early 2006. His trial began in January 2009 and has only just recently completed with verdicts in March. And there are, of course, also other questions about the competence of some of the ICC judges, bearing in mind that they are actually addressing some of the most serious, perhaps the most serious crimes that can be addressed in any court. We have seen full judges of the ICC who have never been lawyers, let alone judges. And perhaps one of the most important questions to be asked pertains to one of the more interesting legal themes, albeit you won't find it in a legal textbook, which is, of course, the law of unintended consequences. Have the actions of the ICC made matters better or worse for the peoples of the countries in which it has chosen to become involved? Our conference today will seek answers to these questions from a very distinguished group of speakers, themselves expert in many of the fields that come together within international justice. We have amongst us today professors of philosophy, international relations, anthropology, and African studies, as well as human rights activists. And of course, we are also surrounded by very distinguished lawyers, including several eminent Queen's Counsel. I would just introduce, if I may, our panel for today. We have the Honourable Lady Justice Sofia Okufu, who is one of Africa's most distinguished jurists. She is a judge of the Supreme Court of Ghana, and she has sat as one of the first judges nominated to the African Court on Human and People's Rights since 2006, and is now the Vice President of that court. She has been a member of the Governing Committee of the Commonwealth Judicial Education Institute and a chairperson of the Alternative Dispute Resolution Task Force. Professor Stephen Chan is a professor of international relations at the School of Oriental and African Studies at the University of London. He is one of Africa's best friends and one of Britain's leading Africanists. He is the author of a very large number of books and studies, not least of which The End of Certainty, Towards a New Internationalism, and Grasping Africa, A Tale of Achievement and Tragedy. Professor Hans Kochler holds the Chair of Political Philosophy in the Faculty of Philosophy at the University of Innsbruck. He has published very widely on issues such as international justice, international tribunals, and, of course, the International Criminal Court. He was appointed by the then UN Secretary General to observe the Lockerbie trial conducted by the Special Scottish Court in the Netherlands. Professor David Chandler is Professor of International Relations and Research Director at the Centre for the Study of Democracy at the Department of Politics and International Relations at the University of Westminster. He is a regular media commentator and the founding editor of the Journal of Intervention and State Building and the editor of the Routledge book series Studies in Intervention and State Building. Dr. Carla Firstman is the director of REDRESS, a human rights organization that helps torture victims obtain justice and reparation. REDRESS works with survivors of torture and to make torturers accountable. Dr. Ferstman was called to the bar in British Columbia and has worked for the UN High Commission for Human Rights and with Amnesty International's International Secretariat as a legal researcher on trials in Central Africa. She's a regular commentator on victims' rights, the International Criminal Court, and the prohibition against torture. Just as a side and a sort of link into my first question to Judge Akuffo, I'm actually reminded of one of my great uncles who was an English lawyer and member of Parliament from 1880 to 1885. he was somewhat of a contrarian and only served one term, I think, as a consequence, because he was known as the champion blocker, and he would seek to block any legislation he could within the British Parliament at that stage in time, even those bills that would normally have gone through unopposed. And this was actually for the simple reason that he thought there was already too much law as of the 1880s. So my first question really to you, Justice Okufu, is there a need for new law, specifically in the realms of international law? Or have we got enough law nationally, enough law regionally? Is there a need for any more institutions?
I believe there is. There is, because there's never a time. I can't imagine how anybody could ever feel that there's just too much law. There might appear to be too much law only because of application or misapplication or neglect in application. And sometimes laws may have been passed to deal with certain specific situations, and those situations then evolve beyond the scope of the law. If you take, for example, the regime within which the ICC was established, there were a whole load of assumptions that obviously were made. Ironically, Africa is amongst the most states represented in the membership of the Rome Treaty system, and yet Africa is now the loudest critic of the court and how it's working, because the law, just the technical outline of the law may seem all right and salutary and everything, but there was not much thought put to application of the law. And when you also think of it, you said something about the law of intended consequences. When the law you've passed does not meet the intended consequences, then it means there's something short that needs to be addressed. And obviously, one wouldn't say that it was intended that the law should be Europeans' court against Africans, but that is how it is working out to be, not because the rest of the world is short of people deserving to appear there. And so more law may be needed, but not necessarily on the ICC level. That's why in the African Union, they have also seen a certain gap, which maybe if that gap had been addressed earlier, the present consequences of the ICC may not have necessarily been the way it is. And that is why there's serious consideration and serious steps being taken to expand the jurisdiction and the mandate and the structure of the existing African Court on Human and People's Rights to bring into being. On paper, yes, there's already in being an African Court of Justice and Human Rights. But even that is being expanded now to include African Criminal Court, so that it would deal with breaches of the international criminal law. And then maybe there might not be the need to drag off everybody to the ICC. And because in terms of intended consequences, you enact a law and you establish a process for it to have a certain effect from where the cases will be originating, but how many people in Africa are even following what's happening with Charles Taylor? And yet, I think even the very sight of a former African head of state or a former African big shot, everybody was, who was holding everybody in thrall, being tried on the African continent by Africans is going to have a deeper impact. For some of such a person's victims, even just the sight might even be enough. And there could be so many other consequences. So the law is good, but the law is not necessarily as it ought to be.
Well, thank you very much for that. Professor Hans Kochler, I mean, is there a gap, do you think, into which the ICC has fitted, or you have, I know, strong views on the role of the UN Security Council within the ICC's statute. Is there some compatibility with the International Criminal Court and the International Court of Justice, or are they so mutually exclusive?
I would say that these courts operate on totally different premises. The International Court of Justice is a court that is part of the United Nations system. Its statute is attached to the UN Charter, and that means that all the United Nations member states are part of this court or have created that court. The International Criminal Court that's an entirely different matter. Interestingly, in the wider public, quite often the two courts are confused just because the seat is in The Hague in the Netherlands, but they have absolutely nothing to do. The International Criminal Court is based on a treaty that has been adopted by a certain number of states, but only by a certain number of states that are also member states of the United Nations, and legally the two courts are not related in any way. The problem, however, is what I would call a birth defect of the Rome Statute of the International Criminal Court. This court is supposed to be a treaty-based international institution to deal with the issues, with the crimes which you have mentioned, but strangely, in one of the articles, or in two of the articles, but one is particularly important, namely 13b of the Rome Statute, this institution grants specific rights to another body, namely the Security Council of the United Nations. And the Security Council of the United Nations is considered to be the supreme executive organ of the United Nations. It is not a judicial body in any way, and its competence or its mandate is to deal with issues of threats to international security or breaches of the peace. And the big problem, first of all, exists in legal terms, and one has to make people aware of it. And in the meantime, I see, for instance, India has raised the point which I have raised since many years now, Article 13b, which gives to the Security Council the right not just to refer situations to the International Criminal Court, but also to create jurisdiction for the court, which otherwise would not exist. Referrals can be made, according to the Rome Statute, by states parties, that means by member states. Okay, that's quite clear, and there is no violation to the international law of the treaties. And the jurisdiction may also be triggered by the initiation of an investigation by the prosecutor, which is also okay and and not in contradiction to the existing international norms. But as far as the Security Council is concerned, a referral of a situation does not require that the crime is within the jurisdiction of the court. That means it effectively creates jurisdiction in terms of territoriality, which the court otherwise would not possess. And the irony is, it does not only create jurisdiction, and that means also obligations for states, resulting from the Rome Statute, but states that are not party to the Rome Statute, as you said, these obligations may be created even by a majority of states in the Security Council that themselves are not party to the Rome Statute and that have absolutely no obligations under that statute. And that brings international power politics right into the center of the exercise of international criminal justice. And for that reason, in my view, one could also say that the Rome Statute of the International Court violates a basic principle of jus cogens, of international law, namely that principle which is based on the maxim of pacta sunt servanda, which is the basic element of the Vienna Convention on the Law of Treaties. And the other side of pacta sunt servanda, of course, is, according to Article 34 of the Vienna Convention on the Law of the Treaties, that no state has any obligation vis-à-vis a treaty which that state has not ratified. And for that reason, one could even claim, because there is this general rule that treaties are automatically, so to speak, invalid if they are found to be in violation of jus cogens. One could even doubt the legitimacy and the legal validity of the Rome Statute of the International Criminal Court. But just one more aspect, getting away from the legal level, we have seen what all of that means in political terms. Now, the court has existed for 10 years. There are only cases from Africa, because only situations in African countries have been referred to it or have been taken up by the prosecutor. That's why I would ask even whether ACC would not be the better acronym for the court, namely African Criminal Court. And the Security Council, and this is the interesting point, has even aggravated this imbalance, because what the Council did, it referred situations in two countries where there was a conflict situation to the court, and both countries are not state parties to the International Criminal Court, namely Sudan and Libya. And in addition to that, which is also quite, which somehow makes evidence the political nature of all of that, if we just take how the situation in Libya has evolved. The referral was made when the conflict was going on. And quite soon after the referral, the prosecutor, so to speak, obliged and did issue arrest warrants for members of the leadership, including the leader of that country at the time. Interestingly, the prosecutor has absolutely shown no interest at all in investigating the circumstances under which the leader of that country has been killed, so that now the ICC cannot continue its investigation or prosecution of that person. And after regime change, interestingly, the prosecutor went to Libya and made quite a good and positive statement about the quality and the standards of the judicial system, and considered and even shared his view that he might have no objection that on the basis of complementarity, which is one of the basic principles of the ICC, of the Rome Statute, Libya might try at least one of the suspects itself on its territory. So this reveals the political nature. Before regime change, there is an interest to have these persons extradited and to have the ICC intervene, and one has created even that jurisdiction. After regime change, suddenly all of this action seems to be totally irrelevant, because to have the son of the leader tried in Libya, they could have had this, they could have got this without an earlier referral. And that's why I personally feel that there is a need now that influential member states in the United Nations system, in the so-called international community, particularly those who carefully weigh the options and who have not yet ratified, such as, for instance, India, make that point that there is no hope for the president of, they cannot give any hope to the president of the International Court who is traveling, who has been traveling around and lobbying to get ratifications. There is no point for him doing this, or he should have no hope that such countries would join, as long as some basic consistency issues in the Rome Statute are not resolved. And one could be very easily resolved. The Security Council may keep eventually its right of referral, although the problem still exists that not all Security Council members are state parties, but it should be a regular referral as that of any state party under the statute. So they just would have to insert the brief formulation, crimes within the jurisdiction of the court. That is omitted just in that particular subparagraph where the right of the Security Council is defined. And as long as this is not happening, and as long as we have power politics as essential element and regulative principle of the administration of justice, I personally see no hope for the International Criminal Court to gain legitimacy and also to become a kind of viable and sustainable project of international criminal justice.
Thank you very much, Professor. Your points are well made, I think, and once again, actually, food for thought, I think, for those who are fascinated about the actual legal standing and the legal space which may exist for the ICC. David Chandler, you've specialized in looking at various aspects of interventionism. Do you think that the argument that the ICC is in effect a sort of judicial interventionism holds water? And also, do you think that international justice can exist in and of itself outside a political framework?
I think that there is a problem with this discussion, and that is our understanding of law and what law can do. And I sort of disagree with Lady Justice about how there isn't really any limits to law and that law is always good. And the intimation, of course, is that if we could only get these good laws into place with agreement, the world might be better, as if law could come before reality or change reality or be used instrumentally in some way. And I think that's really problematic, and it doesn't really work domestically in our own societies. There's all sorts of terrible things happening. We could have laws against child abuse, laws against this, laws against that, laws against drugs. And if we understood law like that, we could go around and be very happy and make wonderful laws all the time, but that doesn't actually mean that anything in the world would change. And there would be a limit to law, and that limit would be that law just becomes a rhetorical expression about us and our moral feelings and our aspirations. And if the law can't actually work in society, if we have laws against drugs or other things that are going on, all that happens is that law isn't really law. It can't really be applied in any sort of universalistic way. It can only be applied fairly arbitrarily, because once law takes on a life of its own and it doesn't come from society and a social consensus and reflect real relations, then there's this big difference. And if we can understand that domestically, that may enable us to reflect a little bit on this international law discussion that we have, with these ethical aspirations to end crimes and bad things and make people accountable. And you can see that people would pay money for that and have conferences and sign up and, create charters and go around the world and lobby for these things. But there was a sort of a gap between those aspirations, and they're good people, and the reality. And I think that to sort of understand that as a problem merely with law might also be problematic, because what we're doing is we're thinking about politics and the world and social relations and Africa and conflict in a way where we're not really starting with an understanding of what's going on, in a way that we're more distant and we're saying we think that these things are bad and should be stopped. But without a relationship to the problem, the chances are that things that you might act on or spend money on aren't really going to help, and they could even make things worse. And I'm not so sure about it being a colonial relation, but it's definitely a relation of distance and a relationship of a lack of connection, accountability, and responsibility in terms of this little bubble of international law stuff. And I think that there's not a lot of necessarily instrumentality in it. I think it's, maybe we could understand the end of the Cold War as a withdrawal from Africa, that there seems to be less at stake and that the distance may have grown, and therefore the rhetoric and the international institutional framework, the international funding for things, has more and more and more of a gap, and it's just more about those people that are making those declarations, reproducing these discourses of law. And I think that's really what it sort of reflects. And to me, I'm not an international lawyer, and maybe that's why I'm not so much in favour of it, but it just sort of shows a certain distance. And I think that's problematic, actually, that what's reflected in these discussions is really a lack of concern with Africa and with what goes on, rather than a sort of colonial, instrumental desire to micromanage. I think it's a distancing.
Stephen Chan, you know Africa, I think, as well as any man. You've actually lived in Africa. You've made a study of the continent and its institutions, your life's work. Do the Africans have a point? Are they sort of justified in feeling a undue focus, or are they being paranoid?
I don't think they're being paranoid. I can understand very, very well a deep concern in Africa. But I think that insofar as it focuses only on the International Criminal Court, it's misplaced, because I think that all of us have to remind ourselves that when we're talking about the ICC, we're only talking about one part of a very, very large international judicial apparatus. In other words, the architecture of international justice is quite vast now. And when you look at it in its totality, it actually covers a very, very great deal of the globe outside of Africa. There's a problematic relationship, as Professor Kochler outlined to us, between the ICC and the United Nations. But in one way or another, particularly because of its relationship with the Security Council, you can say it takes its place within an international architecture in which there are at least 7 United Nations associated special tribunals or courts of one sort or another, covering most of the globe. And in addition, there are other institutions of transnational justice, such as the African Court of Justice, for instance, which the Lady Justice Akuffo represents. But when you look at what's happening just this very week, for instance, you have the final statement of Charles Taylor, a former head of state in Africa. You have the beginnings of the trial of General Mladic, the former Serbian commander in the Balkan Wars. Now, neither of those two judicial arrangements are part of the ICC. They're part of special courts, the Special Court of Sierra Leone, which in Charles Taylor's case is being conducted in The Hague because of reasons of security and sensitivity back in Sierra Leone. And in the case of General Mladic, you're looking at the special International Criminal Tribunal for the former Yugoslavia, which was specially created. And before that special International Tribunal for Yugoslavia, another former head of state has stood trial. That was Mr. Milosevic, the former president of Serbia. When you look, for instance, at that special tribunal, and you look at the number of, let us say, European presidents, leading figures of one sort or another, political and military figures, then you can see that there is a very great deal of spread of this effort to adhere to norms of international justice. Now, I think that the problem is manifold. I agree with a lot of the discussion thus far, but I think that one of the pressing needs is to join up the architecture that purports to represent movements to actualize the norms of international justice. I disagree with Professor Chandler. I think there are international norms. I think they're very problematic. And I think that to give actuality and jurisprudential actuality to them is very, very difficult. But 7 international tribunals is too many. So I think there's a pressing need for a unified apparatus. And the second is that with specific reference to the International Criminal Court, I actually detect a series of problems, including those that Professor Kochler outlined. I think you have internal problems, which I think you alluded to, Mr. Chairman. I would actually locate them very much in one of the 3 chambers of the International Criminal Court, and that is that I don't think we have surety of the robustness and the jurisprudential, as it were, completeness of what goes on in the pre-trial chamber, where the decisions and the preliminary movements are made towards prosecution. I'm not certain of the relationship between the pre-trial chamber and a rather swaggering, full of bravado prosecutor, Mr. Campo, for instance, who has a certain stylistic very, very much of his own. Secondly, I think there is a problem of membership. As you rightly pointed out, and others have rightly pointed out, there's not universal membership. And it's not just that the United States has not ratified the Treaty of Rome, but countries such as Russia and China have not even signed the Treaty of Rome. Insofar as it's not a universal, all-inclusive organ, then I think that is at fault. But I would go further in my critique of the jurisprudential foundation of the court than Professor Kochler has. Not only does the court create special jurisdiction via the Security Council, but the Security Council in doing so may be accused of creating special international law. In other words, it creates the law upon which people are subsequently prosecuted. And this, I think, cannot be, in any fair sense of jurisprudence, sustained as equitable. Now, in those technical terms, I think, yes, anybody brought before the ICC, and that includes the African leaders, they are very, very much the ones who have been brought before this organ, do have cause for complaint, and other African states do have cause for complaint. But very, very much within the broad international framework of international judicial architecture, when you look at that in its entirety, and as I said, it needs joining up, then I think that you can see a very, very different picture, reflecting, I think, a desire to express and institutionalize norms that are against genocide, that are against outrageous crimes against humanity. I don't have a problem with those norms. I've written several books saying that norms have to be very carefully approached because of how they are differently conceived in different countries and different cultures. But I do think there's a common abhorrence of what happens in terms of crimes against humanity. There's a common international abhorrence in terms of a reaction against crimes against genocide. Now, there are unintended consequences of all of these courts and tribunals. We began, in terms of your question, of saying, should African states and African citizens feel insecure or beleaguered because of the ICC? I just wanted to leave you with a reflection of what's happened in countries of the former Yugoslavia, where, of course, you've had, as I've said, a former head of state, President Milosevic, who arraigned against for crimes against humanity and genocide before the special tribunal. I'm sure that if President Tudjman of Croatia had lived, he also would have had indictments made against him. General Mladic is only one Serbian general. You have Croatian generals such as General Gotovina, who've also been arraigned against before the special tribunal. And one of these unintended consequences was very much felt, I think, in the last presidential elections in Croatia, which I attended, in which President Josipovic was elected president. Coincidentally, he was a professor of international law and had written a very, very dense and very, very hopeful book on the International Criminal Court. And he stood on a platform that if he were elected president, he would by all means cooperate with both the special tribunal and with the international judicial architecture in general, including with the International Criminal Court. This was hugely controversial back home, because of course what we're seeing General Mladic being tried for now is primarily the slaughter in Srebrenica in Bosnia. There was an equivalent, although not quite as bloody, in the war in Croatia, when the Serbian militias took Vukovar. And this created huge tensions in terms of the election of Josipovic, because he said we should recognize the international judicial apparatus. And it was only when an advertisement appeared in the Croatian newspapers signed by about 1/2 of the military establishment, but the most outstanding signatory was the one by Brigadier Branko Borkovic. Okay, that's a very, very sort of difficult name to pronounce, but with a nickname added, Mladi Jastreb, which means the young hawk. That was his battle name. Zapovjednik obrane Vukovara, the defender of Vukovar. When the veterans of the defense of Vukovar came to the side of Josipovic, the whole country's politics changed. Now, I think that this does tie in with what Professor Chandler was saying. When you look at the international judicial apparatus, I think we are very much required to look at the consequences in political terms of what it is that we create. And if through the International Criminal Court, and if with its present concentration on African leaders and African war criminals or warlords, whatever you want to call them, if by our concentration on that we create instability within Africa, and if by that we create distrust in the improvement and in adherence to international norms and distrust of the international judicial architecture, then we do the whole cause of international justice a wrong. I think that we may have embarked down a political path where justice is seen rightly or wrongly to be malign and misdirected, but the unintended consequence of that is that in many countries where judicial norms and a faith in justice should be gaining ground, people are losing faith in what justice and its architecture actually means.